Hello.
Hello.
All right, I think we have everyone. If you are just joining us for our event this morning, we are about to start our third and final panel, which is a panel with the question, is common carrier the solution to big tech's censorship? And I will introduce, we have four distinguished
I have
panelists.
no control.
We have four distinguished panelists with us today, and I will go ahead and start introducing them. I think we're waiting to
Can
try
you guys hear me?
Yeah, we can hear
Yes,
you.
we can't see you,
We
however.
can't see you though. I think we're trying to pull up your video, Professor Hamburger. I'm going to go ahead and start introducing everyone, and hopefully we'll get Professor Hamburger's video up shortly. So first off, we have Adam Kandub, who's professor of law at Michigan State University and also a senior fellow at the Center for Renewing America. He was previously the acting assistant secretary of Commerce for Communications and Information, and he joined NTIA as the deputy assistant secretary in April of 2020, and then later joined the Department of Justice as a deputy associate attorney general. He has focused on his work at the Michigan State Law School, has focused as their director of intellectual property, information communications law program, and he holds a JD magna cum laude from Penn Law and a BA magna cum laude from Yale University. Professors Kandub's scholarly interests focus on the law and regulation of communications, internet technology, and he is widely published in the areas of communications regulation and antitrust. In federal courts, including the U.S. Supreme Court, have cited and relied upon his work. Our next panelist is Professor Richard Epstein at the New York University School of Law, where he is the inaugural Lawrence A. Tisch Professor of Law at NYU School of Law. He's also served as the Peter and Kirsten Bedford Senior Fellow at the Hoover Institution since 2000, and he is also the James Parker Hall Distinguished Service Professor of Law Emeritus and a senior lecturer at the University of Chicago. And he has been a member of the American Academy of Arts and Sciences since 1985 and a senior fellow of the Center for Clinical Medical Ethics at the University of Chicago Division of Biological Sciences. And Professor Epstein researches and writes in a broad range of constitutional, economic, historical, and philosophical subjects, and has taught administrative law, antitrust law, communications law, constitutional law, and the list goes on. And Professor Epstein also writes a legal column, The Libertarian, and is a contributor to Ricochet.com and the SCOTUS blog. Our third panelist this morning is Professor Hamburger, who is the Maurice and Hilda Friedman Professor of Law at Columbia Law School and president of the New Civil Liberties Alliance. Before joining Columbia, he was also the John P. Wilson Professor at the University of Chicago Law School. He writes on constitutional law and its history, with particular emphasis on religious liberty, freedom of speech in the press, the judicial office, administrative power, and unconstitutional conditions. He has published several books, The Separation of Church and State, Law and Judicial Duty, Is Administrative Law Unlawful, The Administrative Threat, and Liberal Suppression, Section 501c3, and the Taxation of Speech. And he has a forthcoming book this year called Purchasing Submission, Conditions, Power, and Freedom. He's a member of the American Academy of Arts and Sciences and has also served on the board of directors of the American Society for Legal History. And he has twice received the Sutherland Prize for the most significant contribution to English legal history. And so our fourth and final panelist is Professor Eugene Volokh, who teaches First Amendment law and a First Amendment amicus brief clinic at UCLA School of Law, where he has also often taught copyright law, criminal law, tort law, and a seminar on firearms regulation policy. Before joining UCLA, he clerked for Justice Sandra Day O'Connor on the U.S. Supreme Court and for Judge Alex Kozinski on the U.S. Court of Appeals for the Ninth Circuit. Professor Volokh is a member of the American Law Institute, a member of the American Heritage Dictionary Usage Panel, and the founder and co-author of the Volokh Conspiracy, a leading legal blog. And his work has been cited by opinions in 8 Supreme Court cases and several hundred court opinions in total, as well as several thousand scholarly articles. So as you can see, we have a very distinguished panel today of these law professors who are legal scholars in this field. And our conversation today focuses on common carrier law, particularly asking the question, is common carrier the solution to big tech censorship? So first, I wanted to just ask if someone would be willing to just give us a brief summary of what common carrier law is for those tuning in who might not be as familiar with this field of law. And then I'll ask all of you to share briefly what your opinion is in terms of how common carrier law could be applied to social media platforms and big tech companies. So first, would someone just be willing to give us?
I'm happy to do that since I've done a lot of the history on this particular subject.
Thank you so much.
The basic intuition is as follows. There are many competitive markets, and in those circumstances, the refusal to deal is thought to be the essence of competition. Or otherwise, if you could force somebody to take your business, then it turns out that you get some kind of a dictatorship. But starting very early on with Sir Matthew Hale, it became perceived that there were certain industries that were called, quote, affected with the public interest. And it meant that these applied to essential services, a debated term. And those essential services had no close substitutes. And so what the law said is if you have the only coach that takes you from London to Oxford, you cannot leave people behind. If you have the only inn, you cannot leave them on the street. So they developed a body of law which says that a common carrier is required to take customers on a reasonable and non-discriminatory basis to avoid these kinds of outcomes. These terms each have some meaning to it. The term reasonable means that you have to give them enough money so that they could remain in business. But at the same time, you're not going to allow them to extract the monopoly profit. And the phrase non-discriminatory means that you can't play favorites amongst your customers and decide willy-nilly that you're going to give one the rate at half the other. There's a fear of expression. It gets complicated when the cost of provision of services are different for these different people, and you are allowed, generally speaking, to make cost-justified adjustments. But this creates essentially a very common regulatory scheme. As you move forward in time, the common carriers do not just cover inns and so forth. They cover railroads, they cover essentially electrical grids, gasoline companies, pipelines, and so forth, telecommunications. So a huge portion of the economy is embedded in this. And the modern question is, this technology constantly allows you to come up with close substitutes. You have to ask, is this a durable common carrier type situation? Is it one that can be destroyed and so forth? And the intuition, which I sometimes share, is that if the common carrier says that you can't refuse to deal, if these particular companies have that kind of power, then even on non-price interests, like taking people whose views are adverse to yourself, are they under a duty to serve? That's the basic problem. And the solutions differ, to put it mildly, very widely across different individuals with different presuppositions as to what the right or wrong solution is. So I'll leave it at that.
No, that was extremely helpful. Go ahead, Professor Hamburger. You were going to add.
Thank you. I greatly respect my former colleague Richard's view of common carriers. I've learned a lot about it from him. I just want to draw out a little distinction that he alluded to, but sort of strengthen it, if you will. The distinction between the public function justification and the market dominance justification, and they have different implications. The public function justification note would even apply to a small bus company. It's the public character of the enterprise that really matters. There's also a market dominance justification, which Richard emphasized. And notice that applies to merely private companies engaged in what might not seem public functions. What I want to emphasize here is that the government has actually aided these companies, and therefore the market dominance is not merely private. It's not as if we should say, oh, we shouldn't punish these people for being successful. And 230 is central in this, amongst the other ways in which the government has subsidized its companies, is it's helped establish tech company dominance. Because Section 230 privileges tech communication over print communication and in-person communication. And so, we're not in the realm of private individuals being punished for their success. This is a partly government established dominance.
Yeah, and also, if I could, the question of what problem common carriage is supposed to solve is an old one. Goes back to the beginning of the 20th century, the debate between Bruce Wyman and Burdick. Burdick took the, it's all economics. It's as, do we have easily substitutable products? Wyman took the broader view, actually one that, we find in, let's say, the dissent from Justice Harlan in the civil rights case, that common carriage is really about certain types of industries and activities. Harlan said it was public highways, post offices, turnpikes, places of public amusement. I'm not an historian. I'm not exactly sure what that would refer to in the 19th century, but that you couldn't, as he said, you couldn't really, what does he say? And in public, blacks and whites together in public buildings of whatever race for the purpose of hearing political discussions of the day discussed. And I mean, for better or worse, I mean, this area of the law does have a non-economic aspect to it. And that makes things more difficult. I mean, we like economic regulation because it's precise, because it gives us nice answers. But the historical reality is that common carriage has this other aspect of equal and meaningful social and political participation.
Can I just add something a little bit more concrete to the very helpful general analysis that was offered? Here's an example, or let me give you examples of things that are common carriers and that are not.
Mhm.
Not a common carrier, a newspaper, however dominant in its market, however important it may be. Not a common carrier, a broadcaster. Now, broadcasters have historically been subjected to certain kinds of obligations to carry things they dislike, such as the late and by me unlamented fairness doctrine, also the personal attack rule, rules that are still in place that not quite require them to, but more or less push them towards running candidate ads. So those are not common carriers. What are common carriers? Phone company is a common carrier. That could be a landline monopoly. It could be also the famously competitive cellular phone companies. They're common carriers. The post office is essentially a common carrier. Now, that's run by the government, so that's in part because of the First Amendment. But UPS and FedEx are also common carriers. So a newspaper is entitled to say, we don't want to carry views that we disapprove of. It's contrary to our editorial judgment. What's more, we're providing a service to our customers. We're giving them good ideas, useful, thoughtful ideas, accurate factual accounts. And we're also fighting the problem of information overload. That if we gave them everything, then it would be useless. We're picking and choosing, and we're entitled to do that. A bookstore is kind of like that too. Obviously, a bookstore doesn't pick and choose as much as a newspaper does, because it could have tens of thousands of titles, or maybe even hundreds of thousands for the biggest ones. But they also help fight the problem, especially traditional bricks and mortar bookstores, of information overload. On the other hand, if a phone company says, we're so upset that this phone number on our service is being used, publicly announced as the recruiting number for the KKK, or for Antifa, or for the communists, or for anti-Chinese government protesters, they're not allowed to say we're going to refuse to provide service, because they're a common carrier. Likewise, if UPS and FedEx says, we refuse to deliver packages that we think contain Nazi propaganda or communist propaganda, they can't refuse to carry that. So one question that arises is, where should social media fit within this spectrum?
Yeah.
Although perhaps a better question, let me just finish one thing with, and I'd love to hear, Richard, what you think, is where do the different functions of social media operate within this spectrum? Might it be, for example, that the hosting function, where it just decides whether to carry a particular Twitter feed, let's say, a particular Facebook page, could be a common carrier, but on the other hand, the recommendation function, where it decides what to promote as articles you might enjoy, might be more like a newspaper or more like a broadcaster or not. Richard?
Yeah, there's also another question here. If you go to the historical situation, times were primitive and alternatives were not only scarce, they were non-existent. And so what you did is you had a long and skinny essential service, which there was no close substitute. As you move forward in time, what happens is you could get UPS and you could get FedEx. You get 3 or 4 telecommunications carriers. You could get various boats and airplanes that go on different routes. And you have to decide, therefore, whether or not the presence of competition allows you to give back to the exclusionary model or whether the traditional functions still apply. And there's a big debate over that particular situations. In many cases, it really doesn't matter that much because when you're trying to figure out whether or not you're going to take passengers on a plane, the basic norm is you could throw out the disorderly and the unruly and take everybody else, and nobody really wants to sort of would deviate from that equilibrium. But when you start having content and information, then it turns out that if you regard these as competitors, like newspapers, they can exclude. If you regard them as traditional common carriers, they can't. And the definitions from the historical sources don't point unambiguously in either direction.
If I may, first a framing point, and then I want to engage with what Eugene and Richard just said. The framing point is, I think we should always remember in this conversation that although we're focusing on common carriers, that is not the only justification for anti-discrimination laws in this context. There are other constitutional foundations for that. We needn't dig into that here. We just got to keep in mind this is one of many, and it's related to the others. Now I want to get to the question that my colleagues raise as to what is a common carrier. And I just want to point out that what's conceived to be a common carrier is a flexible thing, and it's expanded or contracted depending on the sort of regulation that's at stake. There's full common carrier regulation, which includes its price controls and all the rest. I suspect most of us have some hesitancy to endorse that in most situations. But then there's a milder common carrier regulation, which is simply the anti-discrimination element. And when the anti-discrimination element has come into play, there have been very broad understandings of what is a common carrier. For in a 1701 case involving a farrier, the farrier could not refuse to shoe somebody's horse. On the other hand, that didn't mean the farrier was subject to price controls and things like that. So we got to keep in mind here is it depends what we're looking at. If we're talking about broad common carrier regulation, as has happened to the phone companies, we might take a narrower view of what a common carrier is. If we're looking at anti-discrimination law, then you have a very broad understanding of what a common carrier is. That's been true in anti-discrimination law throughout the past century in the United States, and it's also true when it gets to some of the First Amendment issues. So to the extent we're talking about anti-discrimination law, our sense of what a common carrier is actually expands a little, is a little broader, and historically that's been true.
So Title II covers restaurants and movie theaters, neither of which comes close to the standard historical definition. And there's a real question, is that good or a bad kind of thing? Because a non-discrimination rule, amongst other things, will retard competition, may make it more difficult to get new entry and so forth. So one should never assume that the broader definitions comes without any kind of a parallel cost.
No, this is all very helpful. And I think we're already kind of starting to get at this, but my next question is then, so what, given those frameworks for kind of thinking about defining a common carrier and what would make a company, justified categorizing it as a common carrier, then what are the arguments and what do you all think in terms of why this classification could be applied to social media platforms? And I guess, even what you kind of clarified, Professor Hamburger, on the public function justification versus the market dominance justification, are both present as it comes to social media platforms? Is one kind of more compelling justification than another? And we can all go in turn and you can all share what you think in terms of applying these the common carrier framework to social media platforms, why the argument exists that they could be regulated as common carriers.
Adam?
Sure. Well, as has been pointed out, it's a vague, and it is a vague term. It's meant many things, from grist mills to places of public amusement, as Justice Harlan said. I think that for lawyers, the vagueness of the category makes us nervous, because we like sharp categories that are justiciable and that judges can make decisions about. But I think I go back to the Harlan dissent, is that people have to be involved in where the public discussion is actually happening in a meaningful way. And for whatever reason, the social media's networks seem to exhibit extreme network effects, and they seem to solidify around a few points. And that for meaningful involvement in that, in those places, there has to be some sort of mild non-discrimination requirement. Now that sort of exercise of state power, it makes people uncomfortable. On the other hand, virtually every institution in our society, our schools, medical provision, housing, they're suffused with these anti-discrimination requirements. Somehow we managed to get along, whether we're burdening unspeakable inefficiencies, I don't know. But I think at the very least, the burden should be on the social media companies to sort of show what really will happen to them, other than Zuckerberg being upset that certain people are having certain discussions.
Mm-hmm.
Look, on the social media side, there has always been a category that you could get rid of unruly people. And Eugene and others have mentioned that, you can probably keep people who are trying to incite riots, steal military incitement, inspire anti-Semitism or something like that all. But the category of misinformation that is used by many of these companies to justify the kinds of exclusions they make is much more pliable and much more dangerous. Generally, most of the things I believe would be described by somebody like Mark Zuckerberg as misinformation. And so, do you want to talk about the side effects of vaccines as a movement against the universal use of them? I think it's a perfectly legitimate topic, even though it may well be that the vaccination side is correct. Do you want to talk about the fact that the COVID vaccine originated in the Wuhan virus laboratory? I think that's a perfectly legitimate subject, and so forth. Do you want to take the people who wrote the Great Barrington Declaration and throw them off the air on the grounds that they're the wrong kind of sciences? I think not. And so what has happened is the ire has come up because the for-cause requirement associated with removal has been stretched to the point that it now looks as though partisans on one side are suppressing their rivals when the taint of illegitimacy or crankiness doesn't seem to be part of the case. And I think that's what it is. And then going back to what Philip said, this is something that bothers people, even for small companies who are doing this. And it bothers you even more if you think, as may well be the case, that since many of these companies have the same kind of quote unquote progressive or liberal bias, they are doing it with tacit collusion one amongst another. And that sort of creates something that makes it look more like a monopoly by way of combination, rather than a series of competitive, independent, free-thinking common carriers. And I think that's constantly in the background in this particular debate. And we don't know what the thing is. And the last ambiguity, I think that should be mentioned, is when are the other guys coming in? So if there were a Parler out there to pick up the conservative stuff, you'd be much less willing to shut down or to get angry at Facebook, but they're not available. When they come available, you may want to change. So it may well be, if the number of viable alternatives is a key issue, the definitions are going to start to go in and out. And from a policy point of view, it's just extremely difficult to say you're on, you're off in different periods, going up and down depending on who succeeds or fails. So you have a lot of administrative problems in addition to all the definitional ones that people have referred to.
That's very helpful. Professor Volek or Professor Hamburger, do either of you want to share your opinion on why we could argue that social media platforms should be regulated as common carriers?
Come on, Eugene.
He's, hold on, he's muted.
I'm muted, sorry. So I think it's important to distinguish different functions of social media platforms. Let me just give you an analogy. If you look at the First Amendment case law having to do with whether it's constitutionally permissible to require property owners to allow speech on their property, there are several cases that say yes sometimes, although not other times. One of them is Rumsfeld v. Fair, where I oversimplify here, but the court said it's constitutionally permissible to require universities to allow military recruiters into the recruitment program. Does that mean universities are common carriers? The court didn't use that terminology, but essentially we're talking about here about the First Amendment law analog of common carrier doctrine. No, no, of course not. Universities have very broad authority to set their curriculum, to decide whom to hire, to decide which speakers to invite, to decide which programs to run, especially when we're talking about private universities. But as to one particular feature of what they do, which is the recruitment, the hosting of recruiters for their students, as to that, essentially, the court said they could be treated as common carriers. Likewise, in the Pruneyard case, shopping malls under California law and now in the law of a few other states have been required to allow members of the public to go onto the property and leaflet or gather signatures. And the U.S. Supreme Court said that's permissible. It's not required by the First Amendment, but it's permissible if the state wants to impose that kind of rule. In a sense, that means that they're kind of common carriers for purposes of this kind of speech. Doesn't mean they have to rent to all shops. Doesn't mean they have to allow all murals that somebody may want to put up.
Yeah.
So it's important to distinguish the functions. Here's my tentative sense. I think that that there's a plausible argument to say that when we're talking about the hosting function, can Donald Trump have the @RealDonaldTrump account? Can Louis Farrakhan have a Facebook page? At least it's plausible to say that the social media companies should be treated like phone companies, or like, again, UPS or FedEx, and be told that essentially you have to carry that speech. I'm not sure that that's a good idea because, there's no problem, almost no problem so bad that government regulation can't make it worse. Maybe it'll make the problems worse. But at least I think that's a plausible argument, again, by analogy to the phone company. On the other hand, if what you're concerned about is that platforms are not promoting certain kinds of speech as much as they're promoting other kinds of speech, not including it in speech you might like or other people have been viewing or we recommend, there it seems to me that the case for common carrier status is quite weak. Because again, I think those social media companies are performing an important function and constitutional protection function of dealing with information overload problems for their users. And solving them that way. So that's what I think is the main distinction, at least at the general level.
I think they're too difficult. Oh, Philip, go ahead. I've talked.
Oh, thank you. I just have 3 quick points. First, I want to actually directly answer Claire's question in the following way. Section 230 already partly treats platforms as common carriers. C1 protects them from being treated as the publisher or speaker, and this is similar to the old common carrier protection from liability for harm caused by goods conveyed and the like. None of the tech companies objected to getting the benefits of sort of partial common carrier status. So the problem with 230 is not that it treats them as a common carrier, but it only does it partly. It does not impose the corresponding duty not to discriminate. So the statute secures them in common carrier privileges without the corresponding responsibilities. And I think that it's important to remember, then therefore it's too late in the day for them to object that they're not common carriers. They wanted this. They coordinated with government to get it. And we should never forget that. Second, Adam mentioned that we all live with anti-discrimination law. And although there are complicated questions about this law that we're always exploring, and it's complicated, but we all live with it. And you and I and everyone listening to this, none of us have legal departments to help us navigate this, and yet somehow we manage to do it. These companies have the largest legal departments and access to law advice that anyone in the country. I think they can handle it. And then I want to get to Richard's point, which we're all worried about. I think it's very important to mention it. The term misinformation, as if this is grounds for censoring people and shutting them up. I just want to remember, Galileo was guilty of misinformation. Darwin was guilty of spreading misinformation. Everything.
Copernicus.
Misinformation. Thanks.
Yeah, but can I mention something? I'm going to take issue with Eugene, at least the qualification. You mentioned 2 cases, and I think each of them has another wrinkle. One of them is, can the military come on to recruit? Generally speaking, I think if the answer is, can the military just knock on the door and say, we want to be there, there's going to be a serious problem. Just the other day when they had the Cedar Point case, they made it pretty clear that a state which requires you to accept a union is going to basically fall to the per se takings rule in a case like Loretto. That would happen here. But what makes these cases much harder is it's the unconstitutional conditions doctrine. Is we giving you money, and so therefore what we want to do is to say, if you want to get our cash, then you have to let the military come in, the Solomon Amendment. And there are just many complications with respect to that. But I think the government was prepared to say, I mean, they won in court, saying if we want to continue that, we can do it. And they did it not only for the unit inside a university that was engaged in the discrimination, they did it for the whole place. So your medical school could go down in flames if your law school got very tough on military recruitment for JAG. And the other thing is on the Pruneyard case, one of the ways in which defendants actually got out of some of these problems is they started using serious time, place, and manner restrictions, which are generally justified. And in certain kinds of shopping centers, it turns out you can shop if you have demonstrators, and in other cases you can't. And so you get some stuff going on that particular dimension as well. So, I mean, what happens is it's not just a common carrier problem, not just a direct regulation problem. Also lurking in the background in many of these cases is the unconstitutional conditions problem.
If I could just very briefly respond, because this is one of the things that when I said I oversimplified Rumsfeld, this is one of the features. It is true that Rumsfeld v. Fair involved a statute that said, as a condition of getting government funds, you have to allow military recruiters. But the decision was broader than that, because the court said, and I quote, "This case doesn't require us to determine when a condition becomes an unconstitutional condition. It's clear that a funding condition cannot be unconstitutional if it would be constitutionally imposed directly, because the First Amendment would not prevent Congress from directly imposing the Solomon Amendment's access requirement. The statute does not place an unconstitutional condition on
Yeah, but the question is, why would that be the case?
Well,
and what's the justification for saying the government gets to come in for military stuff and nobody else can come in? You have to have a kind of government supremacy type argument, which really sits very uneasily with the First Amendment. Yeah, I'm perfectly concede that they're willing to say that. I don't think it's right. And I also think the First Amendment constitutional issue argument is, as always, extremely hairy.
well, so I'm sorry.
I just want to say, I think this is a bit of a sideline from our main conversation, but I also want to say I think it's fascinating. And if you're interested in this topic, forgive the promotionalism, I have a book coming out in September called Purchasing Submission that re-explores unconstitutional conditions. But I actually don't think this is an unconstitutional condition situation we have here.
Yeah, if I can just add a little historical perspective. You know, is it unconstitutional to require communications companies to carry messages? Certainly for common carriers, I mean, it's not. I mean, even in the 19th century, physical interconnection was in fact ruled that it was unconstitutional, it violated their views of substantive process. However, telephone companies were required to submit messages to competitors. I mean, the way it worked is, if, you know, I was trying to call Claire and she was on an independent telephone network and I was AT&T, I call AT&T and their operator would call an operator from the independent telephone company, and then they would call Claire and says, oh, you know, Candid's trying to reach you, get yourself to an AT&T telephone company. So, I mean, the notion that companies engaged in this sort of behavior, in this sort of business, have to carry other people's messages, at least for, you know, most of our history, did not raise constitutional issues.
No, that's helpful.
Can I flag one other constitutional, unconstitutional conditions question here? So I think that the government can indeed require social media companies to operate like phone companies when it comes to their hosting function. And I think Rumsfeld is one precedent for that. Richard argues that it may be badly reasoned, perhaps, but there it is. However, one interesting conditions question is what happens if Congress says, as to the recommendation function, as to your deciding what to promote and what to push out to people as something we recommend or something you might like. We know we can't require you to be non-discriminatory, but we will provide that if you want immunity from libel liability as to what you recommend, then you have to be viewpoint neutral in those recommendations. Whereas if you want to have complete discretion as to what you recommend. We totally understand that you have a First Amendment right to exercise such discretion, but at least as to that, you will not get immunity. So if it turns out what you're recommending is something that's libelous or invasive of privacy or whatever else, then you might be liable. I'm inclined to say that that would probably be constitutional.
Yes,
And I can
I
point
agree.
to specific cases that so hold. I'm not positive that that's a great idea. I'm not positive any of this is a great idea. But that's where I think the conditions question comes in. I think as to the hosting function, the government can use just its sovereign power to say, look, you are like the phone company. Whereas as to the recommendation function, and there's some other functions as well, like the conversation management function, where it polices comments and the like. And replies, there it seems to me, there the government would have to use kind of the carrot of immunity, which now it offers categorically to everybody, and it might provide it.
Yeah, but Eugene, what you've done is open happily a can of worms. Because
Well,
what happens is you start off with these guys being publishers and transmission carriers. Then they start to remove things. Then they put them on disfavored list. Then they put warnings, this stuff is contaminated and so forth. So after a while, they cease to be somebody who's just stoking the stuff onto the situation. And people start thinking of them as editors in some way, shape, or form, or as commentators or as moderators. And so if there is now I am maybe inventing it, but I don't think so, a dual capacity doctrine which limits the application of Section 230. What your distinction does is it fortifies anybody who wants to make that particular claim. And I'm not against that. Look, I think one of the noticeable things about this conversation amongst the people who are very strong-willed types is the amount of diffidence that we have with respect to the fact that we have the quote unquote one right answer. And I think that's actually a very healthy thing. But I do think what happens is the crystallization of really extreme cases of abuse that is defined by some are what drives it. And say Donald Trump, there are people saying you're under a duty to keep him off, and there are other people saying you're under a duty to keep him on. And I don't really think that we have a strong enough theory to decide which of those two guys is strong enough so as to persuade the anti-Trump guy to go his way or the pro-Trump guy to go the other way either. So we are in a bit of a pickle.
all right, can I ask another question? This is so fascinating, but I kind of want to take us into a little bit more of the weeds of some of what this would look like. So, you know, I know Professor Hamburger, you mentioned this, and Professor Kandub, your law review article talks about how, you know, common carriage is always a regulatory deal, and Section 230 has already given them the carrot, if you will, without imposing a corresponding stick of a non-discrimination requirement to encourage these encouraging these platforms to enable users to block objectionable content for themselves. So I just want to ask, what kind of language, you know, would a common carriage requirement kind of take? Senator Hagerty's bill, the 21st Century Speech Act, kind of puts forward some language on this that, platforms that function as common carriers must be available to all users on non-discriminatory terms, free from public or private censorship of political or religious speech, and defines platforms as companies that have over 100 million worldwide active monthly users. So I wanted to ask you all, you know, what would common carrier language and requirements look like if they were to be imposed on these social media companies as a corresponding stick to the Section 230 protections?
I think it's an important question, particularly because although these companies don't really realize it seems yet, they have a choice in front of them. They might get full common carrier regulation, which I don't think would be a good idea, and it would be very bad for them. And they could avoid that if they accede to a simple non-discrimination requirement, in particular, a bar against viewpoint discrimination. In the Texas bill, which I was somewhat involved with, we simply use the language about no discrimination on grounds of religion, race, or viewpoint. And the advantage of this is that you're buying into the whole host of doctrines and knowledge we already have about what this is. And one avoids conflicting with Section 230, not that it's constitutional, but one avoids conflicting with the statute because it really deals with content discrimination, not viewpoint discrimination. And if one merely seeks injunctions backed up with contempt or proceedings, you don't even have to ask for damages. You don't run into the liability language there. So there's a way of doing this quite neatly without even running into the statute, let alone the Constitution.
Well,
really
nothing is that neat. And so, I mean, I'm not, there are a couple of things I'd like to make. One is there's 100 million subscriber figures. The moment you start using size as a condition on this thing, one could argue that it's a kind of a suspect categorization and will expose it to constitutional attack. Two, even if that's not true, you go from 99 to 102 million subscribers, and all of a sudden the boom starts to fall upon you. Third, you have the question is, well, how do you count them anyhow? For example, trying to count full-time equivalents when you're dealing with, how many workers do you have to have before you're subject to a union gets you into these endless disputes, and you're going to start to do something like that here. And the third thing is viewpoint discrimination. It's there, and I think Philip is right, but we don't know how much it's going to carry over. Is viewpoint discrimination going to be sufficient to say that you have to let somebody go on there if they're going to exercise mass slaughter or child pornography or something of the sort? I think the answer he's going to say is no. And I think he's the right answer. But that depends upon your willingness to incorporate not just the non-discrimination part of the First Amendment, but all the other stuff which deals with categorical distinction. So we have open fields, non-discrimination rules, total ban rules, and you have to live with that as well. I think the price is worth paying. And so I would agree with Philip and I would vote for his bill. I would want to take out the 100 million stuff. I would just kind of treat it as a general obligation rather than a monopoly, but I don't know whether I'm going to go to war over that because I don't even know whom I'm fighting.
I would never want to go to war with Richard. He's a dear
Well,
friend.
on the same side, Philip, please.
Yes, but I must say, given that you were emphasizing the market dominance justification,
Yeah, that would be 100 million.
status, I can't imagine that you really want to emphasize that the size of the company is irrelevant. But I'll stop there.
I'm not, look, as I say, I'm not really sure. But I mean, my view about the antitrust stuff on price fixing and so forth, size really matters. But when it comes to the sort of viewpoint discrimination, I'm much less confident that that part of the size issue is as important here as it is somewhere else. And so that's what gives me a little bit of pause. That is, the traditional antitrust concern with size and domination had to do with prices and rates. And now when that is no longer on the table, do we de-emphasize the size component and sort of emphasize the fact that you're a pipeline of some sort or not? I think it's a very hard question. I mean, let me put it this way. If the alternative were the status quo, I would vote for Philip's bill.
Can I ask a question? Oh, go ahead, Professor Bullock.
Eugene.
No, Adam.
No, please go ahead, Eugene, please.
So one question I think we might be asking is, what's really wrong with these platforms making these kinds of decisions? Well, one thing, maybe it's blocking their users' posts. Well, all right, but it's their property. Why not have people go to other services? That's why I think that size matters here. That the concern is that, first of all, there aren't that for certain kinds of platforms, they are, if not monopoly, something really close to it. But more importantly, the concern is basically the one that's raised by usually liberals, in particular, for example, Justice Stevens in his Citizens United dissent, and many people who back that dissent, which is that economic power is being leveraged into political power. And that at some point that becomes dangerous to democracy, especially when we're talking about close elections where a vastly large corporation could sway enough votes to affect the outcome. Now, I actually don't agree with Justice Stevens's dissent in Citizens United. Recall, Citizens United was about whether corporations have the right to speak about candidate elections. And I think they do. I think the majority got that right. And in particular, for example, it came up whether Twitter should be able to label tweets as it thinks that they're wrong or suspect or whatever else. Yes, I think that's part of their free speech rights. But when we're talking about corporations actually blocking people's speech, even speech on their own property, that's where I think Justice Stevens's argument is a pretty powerful argument. I think the left has it right. And people on the right have long acknowledged that in certain situations, certain kinds of excessively broad private power can indeed jeopardize democracy. So that's why I think size really does matter. If you're talking about a small company that is running a small network, as a practical matter, we're not quite as concerned that it will leverage its very minor economic power into comparably minor political power. At the same time, we might be more concerned that even the risk of litigation is going to drown it in litigation expenses and is going to deter it from implementing even useful and valuable filtering mechanisms and the like. So that's why I think if our concern is, and maybe it shouldn't be, but if our concern is the leveraging of economic power into political power, that's something that we should be particularly focused on those entities that have real measurable economic power.
Let me mention a complication, because I think one of the things that's going on in these particular cases, if I get up there and I say, I'm just not carrying you, it's fine. But if I get up there and I say, I'm not going to carry your salacious, immoral, and contradicting, and I make false statements about your position, then it's a situation in which there's an overtone of defamation in cases like this. And if there's an overtone of defamation in that body of law, size does not matter at all. And so if somebody were to say, oh, you know what, these guys who wrote the Great Barrington Situation, they're mass murderers. Even if you said it to a small group of people off of the internet, you can sue them for defamation and you have to establish the requirement. And you could do it here. So what makes it so hard is almost always all of the carriers who take somebody off never say, oh, we're just doing this on a whim. They always give you a reason. And sometimes the reason they give you is one that should put them in the suit. In other cases, it's a reason that should give them an award. And there's just no way with Philip's bill that you could handle the defamation side of this thing. And so long as that is not size sensitive, the entire question is, again, much more complicated than we might otherwise have done. And I'll just ask you, Philip, how many times has there been a controversial removal for something which has been done without any particular acknowledgement and so forth? Maybe there are a few of them, but a lot of them seem to me to have a lot of hoopla around them.
So I think that's right, but a lot depends on what they say.
Well, I agree. The defamation cases always turn on that.
Right. But let me be more specific. Rightly or wrongly, if a service says we're removing something, or even we're not removing it in some other place, we're criticizing it because it's a racist attitude. That is, generally speaking, I oversimplify here, but generally speaking, that's not actionable. That is viewed as opinion. Maybe it shouldn't be, but that's what it is. On the other hand, if they say we're removing this because it was paid for by the North Korean government, then in that case, that's a factual allegation that might very well be libelous. And by the way, is libelous even under the existing scheme, because Section 230C1 doesn't immunize platforms for what they themselves say. So a lot of the removals, or if they just say we're removing it because we think this is not in the best interests of our readers, or our opinion is that on balance this is contrary to the facts, or even we're removing it because it is contrary to the World Health Organization's view of COVID-19, and it is contrary to that view. That's not libelous either. So it turns out, I think, that it's pretty easy for them to explain the reasons for removal without being liable under existing law.
Well, under existing law, but one of the things that I've always taken strong umbrage at is, of course, been the New York Times and Sullivan doctrine. And I much prefer the older law, which says that if you want to call somebody a racist, you give particular illustrations as to what he's done that is wrong, so people could form an independent judgment. But if you just simply use the term about somebody who's not in the popular domain, so there's no knowledge, the older view is that was now a false statement of fact and could be actionable. I'm not a fan of New York Times.
Can I just defend the bill for 1 second?
Just say one thing is
okay. So I think it's actually even harder. But go ahead.
Let's hear from, go ahead, Professor Kandub, and then go ahead, Professor Hamburger, briefly, and then I have another question.
I mean, one thing of the problem is that a lot of what seems to be statements by the platforms is now being immunized by Section 230. So that statements concerning reasons for kicking people off, reasons for, reasons that are violative of the contract are in fact being read by certain courts as protected under Section 230. And that, a lot of, when getting back to the initial point, which is that Claire pointed out, asked about, which is what sort of regime would you want? A lot of this would be better if we could, in fact, as Eugene pointed out, sort of get the liability correct, because common carriage is essentially very much a liability regime. And so being able to make sure that people are, the platforms are being liable for their own statements and their own actions is a big first step in reform of Section 230. Second, be very brief, one of the big requirements of common carriage going back to the 18th century is the publication of tariffs. and the idea that these companies had to be transparent in what they were charging people, not even before they were set by the government or commissions, they had to be public. I think a lot of these problems could be alleviated, and certainly the power that the companies exercise over the political discourse by just greater transparency about who they're removing, the algorithms they're using to promote certain kinds of discussion. I think that's a lot of the anger and frustration people feel, is that they feel as if, there's a puppeteer in our public discourse and we're powerless to figure out what they're doing.
Mhm.
I just want to say I entirely agree with Adam that the comments of the companies should not really be viewed, I think that was your implication, should not really be viewed as protected by Section 230. It's an utter misreading of the statute. And this gets to Richard's concern about the Texas statute. Richard, the statute's aimed at viewpoint discrimination. There's no bar to content discrimination. So in fact, it would greatly reduce the number of instances in which companies would have to opine upon other people's speech, and to which I'd merely add, we all live with defamation law somehow, like anti-discrimination laws, Adam mentioned earlier. We can live with it. And again, I think their legal departments can handle it. So I'm not terribly worried about
No,
that.
I mean, look, I'm just saying it depends, right? But what you say is obviously the right maneuver. You don't want to go after the content stuff, right? You want to go after the viewpoint stuff. But in the COVID kinds of cases and the vaccine cases and so forth, it has been viewpoint discrimination.
Can I ask just two quick practical questions? So the first is something that Professor Kandub brought up in his law review article was about encouraging platforms to actually empower the users to block objectionable content for themselves. So, requiring the non-discrimination requirement on platforms that they can't block and filter content, but they need to, host and carry kind of all content that, but then kind of completing that, I guess, by empowering users themselves then, because, there might be lawful content that, a user might not want to see. And so I'm wondering what you all would think about trying to encourage platforms to enable users to moderate their own experiences. So platforms required to host all content, not discriminate based on viewpoint, but then people could moderate their own experience.
Don't we do that with child locks?
Yeah. If I guess, of course, it's a brilliant idea, Claire.
I mean, perfectly sensible. I don't know, brilliant. Maybe too obvious to be brilliant, but it could be something nonetheless.
And then finally, like on the state level, so if this type of common carriage regulation isn't likely to necessarily pass through Congress anytime soon, Professor Hamburger, you talked about the bill in Texas, should states be trying to pass their own kind of common carrier laws? And then the second part of that with regard to states is, are there other tools at states' disposal, maybe less than common carrier, such as public accommodation law, that they should be utilizing? I know that we have some state participants on this call, so how would you kind of advise state legislators, state actors when it comes to common carrier approaches?
Yeah, I think we don't need full common carrier regulation. That's really jumping a little too fast, to put it mildly. And I recommend folks just look at the Texas bill or variants thereof. It's the point is simply we live with anti-discrimination laws. Another anti-discrimination law won't do much harm and may do a lot of good. And it's perfectly appropriate for, how should I put it, 50 different common carrier flowers to bloom in different states.
By the way, is that true for a network industry when there's a dormant commerce clause question
Right.
in the background?
So it turns out that that's a hugely important and complicated question. I tried to look into it, and it's not completely clear, and I don't think I've exhausted all the possible research on this. But here is a rough version of what I've found. Courts do indeed have some concern about extraterritoriality, and then what happens when one state, could be Texas, could be Wyoming, to take a very small state, one state tries to impose a rule that basically affects behavior all over the country. And there may be some people maybe legislatures in other states want to encourage platforms to block based on viewpoint because they think it's in the interest of the users in those states. So turns out that there is a good deal of extraterritoriality that is allowed. For example, the libel law of one state is often applied to the speech in another state. So it's complicated. But generally speaking, I think it's more likely that these things would be upheld against the Dormant Commerce Clause challenge if the statute basically limits itself to speech maybe said by people in the state, maybe read by people in the state, maybe both. So imagine the clearest example, imagine that Wyoming says, look, any speech that is posted by Wyoming residents has to be readable by Wyoming residents without regard to viewpoint. So if you want to impose a different rule in other states, we leave it to those state legislatures to deal with. But if it's Wyoming speech, it has to be protected.
Well, then it's not interstate commerce. And so the question is, not only do we have the state stuff, but we have the foreign stuff. There's that famous case in international conflicts of law, shall the courts of Tobago rule the world, right? And the question is whether or not Philip Hamburger, operating out of Austin, Texas, is the new court of Tobago. My inclination, by the way, is to rise above principle and to think that this is okay. And let me put it this way, it's a balancing test, Philip. I think I would probably strike you down if you were trying to go after content selection. I don't think I would stop you down for going after viewpoint discrimination, because I think that's something which is much more widely shared. And so the conflicts across state lines are supposed to be less. So there's a line for your brief.
Professor Hamburger, did you finish?
If I could just say one thing, Claire, just one. This issue has been addressed by the DC Circuit in reviewing the Vermont network neutrality laws and by a district court in California in reviewing the California network neutrality laws, the California online privacy laws, which really do have an extraterritorial effect. And they said it was okay. And I think they present very similar issues. I think the bigger concern is if the FCC, those decisions were based upon the idea that the FCC has in fact not regulated in this area because it's regulating under Title II and it's explicitly refrained from regulating under Title is regulating under Title I is refrained from regulating under Title II of the Communications Act. However, if the FCC were to write a network neutrality order, which the Dems seem to want to do, there would be a very good chance that that could preempt any state common carriage regulation of social media. So that's just, I think.
I just want to go back then to Professor Hamburger, actually, in light of what you just shared, Adam. So then is there a possibility if the FCC starts regulating the internet under Title II again and preempts states from imposing their own common carrier regulations, that states could turn to lesser vehicles like public accommodation law? And I think you were saying something about that, Professor Hamburger. So I don't know if that's another possible route at this issue.
No.
Oh,
Philip, you're muted, so I'm speaking for you.
Oh, thank you. Well, then I'll speak especially well. Thank you.
I said no. I think, in effect, where you place this in the statutory book has nothing to do with this legality.
I actually think that I don't think the FCC can displace the state's capacity to regulate discrimination, and I therefore think the any FCC rule would not get very far. I'll go further. There are very interesting questions that the Supreme Court is aware of, though they have not discussed it yet, about the degree to which the expansion of the Commerce Clause has inflated federal control of speech. And that, although they may not turn back on the Commerce Clause, I think will get their attention as to the dangers of taking too expansive a view of any federal control of information or speech. That's a grave constitutional problem. Any well-drafted statute, and we'll see, but any well-drafted statute should be able to avoid these problems, including the Dormant Commerce Clause doctrine, which, by the way, is itself unconstitutional, but that's another conversation.
That's a different conversation.
And I want to explain. And yes, and I just want to add finally that we can never forget a technological aspect of this, which is the use of VPNs. The reality is you don't have to go to Texas or South Dakota to be there for purposes of speech. There are all sorts of subtle ways in which a statute can set up opportunities for wide-ranging speech without ever coming near another state's capacity to regulate.
Yeah, I would just to possibly take another perspective on Professor Hamburger's point. I think the FCC v. Iowa Utilities, I mean, I agree that the federal government can't limit the state's ability to regulate discrimination. So if the statute, as the Texas bill is phrased, is in terms of discrimination, more like a public accommodation statute. But in FCC v. Iowa Utilities, the court essentially said that the FCC can regulate intrastate communications if it affects in any way the interstate. So I mean, we'll see, but I mean, I think it's something that
Yes.
is a possibility.
It'll be really, forgive me, I think it'll be really quite amazing, quite shocking if it is to protect the tech companies that suddenly state anti-discrimination laws are held to be unlawful under federal law. I just don't see it happening.
Well, I tend to think that the FCC probably, the preemption, I think, is going to be there. I think that's your position, isn't it, Adam?
Yeah, I mean, I think it's a
I
problem.
mean, certainly, it may not be under current statutes, but I certainly think you could fix the federal statute so as to have explicit preemption, and so long as it's within the scope of the Commerce Clause, as regrettably it is, it's there. And a lot of what Philip is saying, in effect, is what I said about defamation law. We're always in second best land. If we take the current law on defamation, you may be right. You take a good law on defamation, you may be wrong. You take the current law on the preemption doctrine, you may be right. You take the correct view, it may be wrong. You take the current view on dormant commerce opposed to the correct view. I mean, one of the things that happens is there's so many fissures in the law that we live with existing statutes, all of which come to the fore when we try to put new legislation forward, which is why we are all commendably diffident in response to your questions, Ms. Morell.
No, that was a wonderful conclusion. I was about to say, unfortunately, we're at time. I feel like there's a million threads of this conversation that we could continue to pick up and dive into deeper. But for the sake of everyone's time and all of your time today, we'll wrap this up for now. And thank you to all four of you for giving us your time and your expertise. We really appreciate it. It was fascinating, and you've given us a lot to think about. So thank you
Great
all.
to see you again, Jean and Philip, and nice to meet you, Adam, right?
Real pleasure.
And Claire,
Good
thank you.
seeing
for doing
everyone.
such a
Thank you,
good
Claire.
job.
Great job.
Yes.
Bye-bye,
Thank you very much.
Thank you.
Thank you.